Hi, I am George, and it is my pleasure to welcome you to our YouTube channel. In today's session, we delve into a captivating paper authored by A.H. Angelo and Sarah Mead titled, A New Civil Code in Seychelles. On the 1st of July 2021, the Civil Code of Seychelles Act 2020 passed into force. It marked the end of a comprehensive and inclusive law reform process, which commenced in 2013. The outcome is a revised code that better reflects modern Seychelles society and which is consistent with the Constitution and Seychelles international law obligations. This paper provides an overview of the new code.
Aboutissement d'un processus législatif débuté en 2013, la loi 2020 portant réforme du Code civil des Seychelles est entrée en vigueur le 1er juillet 2021. Ce Code civil refondu et actualisé reflète l'évolution de la société contemporaine des Seychelles. Il lui permet également d'être aujourd'hui en conformité avec les dispositions de la Constitution des Seychelles et avec les obligations de cet État au regard des règles du droit international. L'article donne au lecteur un aperçu de l'architecture du nouveau code ainsi qu'un exposé de ses dispositions principales.
A brief history. The Civil Code of Seychelles Act 1975 Code came into force on the 1st of January 1976, a few months before Seychelles' independence from Britain on the 29th of June 1976. Based on the Napoleonic Code introduced in Mauritius and Seychelles in 1808, the 1975 Code was firmly rooted in the civil tradition. However, in addition to being in English, it contains certain common law elements. This legal hybridization reflects Seychelles' colonial history. First colonized by the French, it was later colonized by Britain before obtaining independence. As explained by Toomey J.A. The result is a micro-jurisdiction that combines both the civil law of France and the common law of England. Caught between European colonial legal traditions and the legacy of its African heritage, the Seychelles legal tradition is now seeking its own identity. The entry into force of the Civil Code of Seychelles Act 2020, revised code, is part of that new identity. Review process. The project for the review of the 1975 Code was launched on the 6th of May 2013. The aim of the review was to take account of 40 years of social, constitutional, and other legal developments since the enactment of the 1975 Code. In particular, it was necessary to ensure consistency between the Civil Code and the 1993 Constitution of the Republic of Seychelles and Seychelles' obligations under international law. Consistent with international human rights law, the Constitution emphasizes the equality and dignity of all human beings and protects the right of every person to equal protection of the law without discrimination. Accordingly, provisions in the 1975 Code which discriminated on the grounds of sex, religion, property, birth, or other status needed to be amended. A committee of 9, chaired by Justice of Appeal and former Chief Justice Mathilda Toomey, was charged with leading the review process and proposing reforms desirable to reflect contemporary needs and conditions of Seychelles. For this, they were to consult as widely as possible with interested parties. Between August 2013 and June 2016, the committee had 34 formal working sessions. These were open to the public and had an average attendance of 12. The work of the committee ended with the production of a draft revised code, 2,281 articles and 323 pages, a supporting commentary, 157 pages, and a supporting draft amendment bill and concordances. In April 2017, the Cabinet gave approval for a public consultation process to be held on the changes to the Civil Code proposed by the committee. This eventually led to the Civil Code of Seychelles Bill 2018. The bill noted that the bill reflects a thoroughgoing revision and modernizing of the code. Specifically, the code has been revised to be consistent with the Constitution of Seychelles, with particular consequences for the rights of children and women. The bill reflects judicial experience with the Civil Code 1975 and provides greater certainty in respect of property rights and, with its consistent use of terminology and structure, it provides the basic law of Seychelles in a more accessible form. On the 16th of July 2018, the bill passed its first reading in the National Assembly. The Assembly then adjourned, and members of the National Assembly met in committee in the Members' Lounge for 4 full days from 17th to 20th of July 2018 to discuss the proposed changes and ask questions of an expert panel which included the Attorney General and members of the Mauritian Law Reform Commission. The meetings were chaired by the Speaker and televised live to the public. Further meetings were held on the 14th of June 2019 to complete these discussions. This led to an amended bill in June 2021, the Civil Code Amendment Bill 2021. The first reading of the revised bill took place on the 22nd of June 2021, with the second and third readings following on the 23rd of June 2021. The Civil Code of Seychelles, consequence of Enactment Bill 2021, and the Curatel Bill 2021 were passed at the same time. On the 23rd of November 2020, the President assented to the Civil Code of Seychelles Act 2020, and on the 1st of July 2021, the revised code came into force. The revised code provides that, on the termination of a qualifying relationship of 7 years, parties share equally the property which has been acquired by each during the relationship in the context of the relationship. The revised code defines a qualifying relationship as either a marriage or a domestic relationship between two persons of full age and capacity, characterized by stability and continuity, and to which there is no legal impediment. In brief, the changes are as follows. For married couples, where the relationship terminates prior to 7 years, the law remains unchanged. For termination after 7 years, the revised code provides for equal division of the relationship property as a statutory right. This broadly reflects how the courts pre-2020 exercised their discretion to make a property order in respect of relationship property, acquisitions only. For other couples, where the domestic relationship terminates prior to 7 years, the law has been changed to give courts a discretion to grant a party to the relationship an in rem right in the relationship property, as with married couples. After 7 years, the revised code provides for the equal division of the acquired relationship property as a statutory right, the same as for married couples. Main changes. The revised code retains the three-book structure of the Code Napoleon and reproduces, in modern drafting form, approximately 90% of the 1975 Code. The most significant changes are here set out in brief. Book 1. Book 1 contains provisions relating to civil rights, descent, and other aspects of family law. Property rights of domestic partners. Book 1. The most important change in Book 1 relates to the law governing the division of relationship property on the termination of unmarried, stable, and continuous relationships, domestic relationships. Such relationships are generally referred to in Seychelles as en ménage relationships when between a man and a woman. For many years, the courts and the Seychelles community struggled with the property consequences of the termination of long-term domestic relationships. The 1975 Code did not make provision for the inter vivos division of relationship property. For married couples, the courts relied on powers under the Matrimonial Causes Act to make in rem property orders to distribute relationship property if the marriage ended inter vivos. The law did not provide a period after which relationship property was to be shared equally, but the case law suggested that this occurred after about 10 years. No such statutory provision existed in relation to long-term domestic relationships. A party to a failed domestic or en ménage relationship was typically restricted to seeking a restitutionary right, unjust enrichment, and in personam action. This required proving contribution to the relationship property in kind, for instance, contribution to mortgage repayments. The revised code also contains an explicit provision that the statutory regime is one of separation. Concurrent qualifying relationships are possible, but marriage retains a privileged status under the revised code. Furthermore, because a qualifying relationship is not defined as between a man and a woman, a same-sex relationship can also be qualifying relationship under the revised code. This may serve to remedy concerns relating to any restrictive definition of marriage. The reason for changes in the law relating to the division of relationship property was concern for the material welfare and the property inequality that resulted from the law under the 1975 Code. In Seychelles, most domestic relationships are not marriages, and the substantial assets of the relationship are often held in the name of the male partner. Women therefore often faced hardship following the breakdown of the relationship, as evidenced by the case law. The changes also serve to bring Seychelles into line with its commitments under international law, specifically the Convention on the Elimination of All Forms of Discrimination Against Women. Reintegration of law on marriage. The revised code also reintegrates the law relating to marriage and matrimonial causes back in the Civil Code. The 1975 Code dealt with some matters related to marriage. Over time, both the basic rules relating to marriage and those relating to matrimonial relationships had been dealt with primarily by separate statutes, notably the Civil Status Act, Status of Married Women Act, and the Matrimonial Causes Act. Matters of substance relating to the law on marriage have been returned to the Act to confirm the integrity of the Code and for ease of use. Book 2. Book 2 contains provisions relating to property in general, including ownership, movable, and immovable property rights. Droit de superficie. The most significant change in Book 2 is the codification of droit de superficie. A droit de superficie is an immovable property right found in civil law jurisdictions. It concerns the division of property rights between the bare owner of the land and the superficiaire, who is the owner of part of the surface of the land. The 1975 Code made no provision for droit de superficie. Rather, the right was a creature of equity developed by the courts to address a perceived hardship. Often in Seychelles, landowners give permission to third parties, usually family members, to build on their land. A parent, for instance, might give permission to a daughter to build a house on the edge of their property, and later have a change of mind and ask the daughter to remove the house. The daughter, in such a case, might claim a droit de superficie to continue living on the land. The nature of droit de superficie under Seychelles law has been a source of significant confusion for some time, as reflected in the case law. The revised code sought to clarify the nature of the right and to bring certainty to the law. Pursuant to the revised code, a droit de superficie is a right conferred on a person other than the owner of the land to enjoy the surface of the land. It is a real right and is both alienable and inheritable, subject to any period specified in a written agreement creating it, and can be created by agreement, prescription, alienation, or court order. While providing much-needed clarification to the law, the new provisions raise questions in relation to the land registration system. The Land Registration Act 1967 establishes a system of title based on its English counterpart. In order to simplify the process by which land transactions are carried out, the Act stipulates that entry into the register perfects the transfer of land and certifies absolute title. No provision is made in the Act for registering a droit de superficie, but practice was to treat the droit as an overriding interest. This practice is now provided for in the revised code. It expressly specifies that a droit de superficie is an overriding interest for the purposes of Section 25 of the Land Registration Act. This brings into question the certified absolute title envisaged by the land registration system. Book 3. Book 3 contains provisions relating to succession and obligations, including contracts, delicts, and unjust enrichment. Testamentary freedom. In a significant departure from the 1975 Code, the revised D-Code introduces testamentary freedom in place of the fixed heirship system 31. The 1975 Code reflected the French approach to property on death, with the property of the deceased transferring automatically to the heirs. A person had limited freedom over how they apportioned their estate on death. For instance, a testator survived by children had freedom of testation over only 1/4 to 1/2 of the succession. There is now a strong sense of individual property rights in Seychelles, so the changes in the revised code better reflect modern Seychelles society's attitude to property. Under the revised code, a person can decide freely how to distribute their property on death, as they can in life. The concern that this might result in the interests of dependents not being met is addressed by provisions that protect their interests. Where inadequate provision is made in a deceased person's will for the survivor of a qualifying relationship and children and parents of the deceased, who were at the time of the death of the deceased wholly or partly dependent on the deceased for maintenance, may make application under this article. A court can make an order for maintenance in favor of such dependents. The introduction of testamentary freedom rendered unnecessary the provisions in the 1975 Code on the disposable portion and reduction, which have therefore been removed from the revised code. Inheritance rights for domestic partners. The revised code makes significant changes to the law relating to the succession rights of unmarried parties of long-term domestic relationships. The 1975 Code ensured that a surviving spouse received a portion of a deceased spouse's estate. However, a party to a long-term domestic relationship was legally entitled to property of the deceased partner, only if they could establish that the estate was unjustly enriched. Any claim would need to be brought against the heirs to the estate. If the deceased partner died testate, any provision in the will in favor of a domestic partner was limited to what was left over from the reserved portion. Equalizing the rights of children. The 1975 Code distinguished between legitimate and adulterine children for the purposes of succession, with adulterine children receiving half of the share of legitimate children. The 1975 Code noted, "The fraction of the adulterine children's part of the reserve, which represents the reduction, shall accrue exclusively to the children of the marriage which has been effected by the adultery." The revised Code equalizes the rights of children. Children have the same rights under the revised Code, whether born of marriage, outside of marriage, or if one of the child's parents was married to another party at the time of conception. Given almost 80% of children in Seychelles are born outside marriage, this is an important change in the civil law of Seychelles. It also is consistent with the equality provisions in the Constitution, and with the Convention on the Rights of the Child, which has been ratified by Seychelles. The equalizing of children's rights also impacts on the law relating to the establishment of parenthood, which is part of Book 1. Co-ownership and fiduciaries. Finally, a peculiarity of the 1975 Code was the law relating to co-owned property. Due to concerns regarding excessive fragmentation of land and to avoid land becoming unmarketable, the 1975 Code established a system whereby a fiduciary held co-owned immovable property on behalf of the co-owners. The function of the fiduciary was to hold, manage, and administer the property honestly, diligently, and in a business-like manner, as if he were the sole owner of the property. The fiduciary concept was an attempt to graft onto Seychelles law the English concept of the trust for sale, without introducing the concept of trust itself. The provisions concerning co-owned property under the 1975 Code caused confusion and unnecessary hardship. Firstly, the 1975 Code provided that the fiduciary alone could deal with the land, and that the right of co-ownership was to be converted into a claim to a like share in the proceeds of sale of any such property. At the same time, the fiduciary did not have any legal right in the property itself, and the provision suggested that a co-owner could sell his or her share to a third party without acting through the fiduciary. The courts undertook significant interpretive exercises to try to make sense of the former provisions, but ultimately failed to clarify what rights a co-owner had vis-a-vis the fiduciary. Secondly, the requirement to appoint a fiduciary to sell the property, which may have been in the family for some time, was often unnecessary. Some heirs preferred to stay in indivision on the family land. There was also evidence of fiduciaries not doing their job properly, causing land to remain tied up. Conclusion. The vast majority of the 1975 Code remains intact, albeit in modern drafting form. This signals a desire on the part of Seychelles to retain its civil law heritage. The changes set out in this article, however, bring Seychelles law into line with the modern realities of Seychelles society. There are notable changes that are not covered in this brief overview. For instance, the revised code includes changes to the law on encroachment, 56 delict law by the addition of the delict of troubles de voisinage and back letters. A full study of the revision process would be a fitting recognition of the landmark nature of the revision process.